The Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons have business before the court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
The place clears out and the donuts are gone. Well, welcome to a session of oral arguments here in Jacksonville. I am Jim Edwards, Chief Judge. To my right is Judge Scott Maycliffe. To my left is Judge Adrian Sal. We have two cases this morning on our docket. For each of them, 20 minutes per side. For appellant, if you want anything other than 5 minutes of rebuttal time, let me know. We can make that adjustment. And if you have a noisemaker, please put it on silent because it will go off at absolutely the worst time. Guaranteed, never fails. So, with that, our first case on the docket is 23-18-28, Rodney Hartbauer versus R.J. Reynolds Tobacco Company, etc. And John, whenever you're ready.
Thank you, Your Honor, and good morning. My name is Jeff Mansell. I represent the estate of Patricia Hartbauer, the appellant in this case. I'll begin by thanking you all for your hospitality and for letting me drink coffee immediately before oral argument. I hope I do not overindulge. Otherwise, may it please the court. 5 minutes for rebuttal will be fine for me. Thank you. We ask that this court reverse the order of the trial court, which denied leave to amend a complaint to assert a claim for punitive damages. The trial court erred in two respects. First, it failed to apply properly the statutes that govern punitive damages, Section 768-72 governing the procedure for amending a complaint, and 768-73, which governs the procedures for a subsequent award of punitive damages. Second, the trial court failed to follow the binding precedent of this court from the state of Blakely case and the state of Despain case, which instruct the trial courts on how they view and how they manage a plaintiff's proffer when seeking leave to amend for punitive damages. Beginning with the statutes, 768-72 contemplates only that a plaintiff must make a reasonable showing by proffering evidence or by placing evidence in a record, which would provide a reasonable basis for the recovery of punitive damages. Although that is not a nothing requirement, it is not as stringent as what the trial court imposed in this case. By any measure, the estate satisfied that burden by bringing forward evidence, both in the record and proffering evidence, which has been found to be sufficient in several cases against R.J. Reynolds for upholding awards of punitive damages. And I would suggest that where evidence is sufficient to satisfy a burden at trial, it is more than sufficient to satisfy the proffer for purposes of amending a complaint.
Counsel, what exactly does recovery of such damages mean? Does that mean that you would actually get a judgment for them?
I think the best way to interpret the statute, looking at the whole text of both 768-72 and 768-73, is to say that a reasonable basis for recovery of punitive damages would mean a reasonable evidentiary basis for the jury to award punitive damages. It does not necessarily mean that the plaintiff will get a final judgment for punitive damages. And I think that was the mistake of the trial court by looking past the procedure that this statute calls for and gazing forward to the next procedural step in the case. And the reason that's a problem is in the text of these two statutes, because the procedure in 768-73, by its terms, contemplates that a plaintiff is already seeking punitive damages, because it lays out a procedure by which, before an award of punitive damages, a defendant can show that it has been punished already for the same course of conduct, and before a final judgment is entered on an award given by the jury, it allows the trial court to examine what the ratio is, the factors in subsection 1 of the statute. So the reasonable basis for an award of punitive damages should be interpreted to mean, and I think generally has been interpreted to mean, there's a reasonable basis for a jury to look at this evidence and say, this is outrageous conduct. And that interpretation accords with the different roles that a jury has, the different roles that the jury and the court have when dealing with a complaint seeking punitive damages. The jury's job is not to determine whether its award is in line with the Constitution or whether its award is in line with the statutes, what otherwise Florida law provides, except as juries are instructed.
It would have been easier for the legislature to use the same words in both statutes, wouldn't it?
Well, yeah, it would be easier if the statutes were written a little bit differently. We have different words between the two statutes for sure. We also have the same word, award, being used in 768-73, where it clearly means different things when it is used in different spots. In some portions of the statute, award clearly means final judgment. The court may not award, means the court may not enter final judgment. But what the jury awards is something very different. The role of the jury, and this is, we have cases cited for this proposition, State Farm versus Campbell, Johansson versus Combustion Engineering. The role of the jury is to express the community's and society's outrage for what the defendant has done. When it does this, it is a jury is naturally swayed by some passion because it has heard evidence that causes it, as the representatives of society, to say outrageous. That is the classic formulation of the basis for punitive damages. So what the statutes contemplate is that these roles remain intact. A jury is not instructed at trial that R.J. Reynolds has already been punished this amount, and you can only award less than that. Florida law provides that generally it has to be no more than a 3-to-1 ratio, so just keep that in mind. We don't instruct juries about that at all. We instruct them to look at the evidence, how to look at the evidence, and then exercise their discretion. And then the court acts as a check on the jury's expression of outrage. And there are multiple ways that the court does that. There are Florida statutes, obviously, as we've discussed in this case, and there's the constitutional limit on punitive damages awards. But the constitutional limit, again, does not apply to what the jury does. It applies to what the court does after the jury has done its job. And the constitutional analysis has always been the last step of the process. And that I bring that up because there's a suggestion from the defendant that the order that you would go in, and the reason that they consider the amendment futile, their proposed order would be to first look at the jury awards and then bring it in line with what the due process clause requires in accordance with what the Supreme Court of the United States has told us. And then only after that, apply the set-off for previous awards. Well, I suppose if that were the way we would do things, then we stop before we start, because a 3-to-1 ratio is going to be less than $450 million or whatever the figure is for past punitive damages awards. But the statute
doesn't really tell us what order to go in, does it?
No, it doesn't, and that's why I'm suggesting a logical approach. And I think, although it's not explicitly delineated in the text, it is strongly suggested by the text, because the text of subsection 2 in section 768-73, and I apologize if I get numbers wrong, but I'm running a lot through my head as I argue this case. The text sets out an order that would go when the plaintiff is now seeking an award of punitive damages, which I suggest means the complaint has already been amended. The defendant brings forward evidence that it's already been punished for the same course of conduct for which this plaintiff is seeking punitive damages. The burden shifts to the plaintiff to prove by clear and convincing evidence that this punishment was insufficient. Now, the fact that there is a burden of proof on the plaintiff necessarily implies that there is a record to be developed. And part of that record is going to be the sort of financial discovery you take after you've been granted leave to amend your complaint, because we cannot look at the financial resources of the defendant under Florida law until we've been granted leave to amend. Now, that is a very important step, because we have to go to the court, and the court has to make an explicit finding under the statute that the defendant has not been punished enough if we are to proceed to trial and allow the jury to consider whether to award punitive damages. Because the plaintiff has that burden, she or he has to be allowed to develop a record, take that discovery, and come to court. And I would suggest it cannot be futile to do exactly what the statute commands, which is these distinct steps of amending the complaint, defendant's showing of past punishment, plaintiff's showing that punishment was inadequate. If we were to decide that it was futile, then the statute would be eviscerated of all meaning, because it really only comes into play when a defendant has been punished before, and when a defendant has been punished before, the chances are very high that the defendant has been punished more than a 3-to-1 ratio of what this individual plaintiff has suffered in damages. That's the nature of cases like these, where a defendant has engaged in a course of conduct that is outrageous. Multiple juries are going to come to the conclusion that the defendant's conduct has been outrageous. I am aware, of course, of the Summers decision out of the 3rd District, which agrees, in my opinion, agrees with the trial court's analysis and with Reynolds' argument in this case.
In Summers, had there already been a punitive damage award though? I may be thinking of the wrong case, but I thought perhaps in Summers there was $1 million punitive award.
Oh, gosh, my opposing counsel would probably be able to answer that better, but
You can deal with it in rebuttal rather than spend your time trying to come up with it right now. I may be mistaken.
Yeah, I was treating it as the same posture in this case. But regardless, the analysis that the trial court employed is, and what R.J. Reynolds suggested in the trial court and what they suggest on appeal, rests on a misstatement of the law. And this is the misstatement, that the Constitution places a limit on what a jury may award. And the Constitution does no such thing, and I've already discussed that. The Constitution only comes into play as a check on what the jury has already done. So to say, as the trial court did in this case, that amendment is futile because the plaintiff could never recover this much in damages, well, of course we can't recover that much. That's the point of the statute. The statute limits what a plaintiff can recover in a final judgment. But it does not limit in any way what a jury may award. And the statute suggests the jury should be considering the entire course of conduct and all the damages that it has caused in the past.
Do you assign any significance to 76873 subsection 2's requirement that the defendant establish before trial that a successive award of punitive damages would be inappropriate?
Yes, I do. I think that goes to the, what I would call strongly implied, if not explicit, order of things. Because a defendant cannot challenge something before trial that is not raised in the pleadings. If punitive damages are not raised in the pleadings, then there is nothing for the defendant to do before trial to address previous.
Does your argument as to the need for financial discovery preclude the trial court from addressing both amendment for claim and whether or not an award would be successive at the same time? Does the need for that discovery hinder the trial court's ability to address both issues at the same hearing or close in time thereto?
I think the way you phrased it, I would say that the court could say that, like what Reynolds did in response to the motion in this case, the court could say, well, the defendant has made a prima facie showing that it has already been punished. What I don't think the court can do is take the next step and make a finding as to whether that punishment has been adequate or not. Because I think that, because it's subject to a clear and convincing standard that calls for an evidentiary hearing, and second, because in the posture of this case, the issue was only raised in response to a motion that had already been set for a non-evidentiary hearing. It doesn't really afford the plaintiff an opportunity to marshal that evidence before the court and ask the court reasonably to make an explicit finding on it.
Did you request an evidentiary hearing at any point?
Yeah, I would say yes. I don't know that trial counsel used the term, I hereby request an evidentiary ruling, but it was clear in the argument when I reviewed the transcript that what counsel was saying is, we're just not there yet, Your Honor. We need to come back and do that after I'm granted leave to amend this complaint. So I would say, short of saying, Your Honor, I hereby invoke evidentiary hearing, I think fairly read the record says we requested an evidentiary hearing. Before I run into my rebuttal time, I just want to note that there was an alternative survival claim. The trial court noted in its order that there was an alternatively pleaded survival claim. That would not have been subject to the statutes that we've been discussing. And the trial court's conclusion that the proposed amended complaint was not the right vehicle for it, the trial court wrongly concluded that kept the trial court from allowing amendment as to the survival claim.
The survival claim, as I read it, was a contingency if and only if something caused the death of the decedent other than smoking. And what proof was there at all of that? I mean, What allegation was there of that other than just kind of a brief mention in that claim?
There was no proof of it, Your Honor. We were not put to our proof on that. I can only say that the defendant generally denied the allegations of the complaint, which triggered the condition, which is the defendant contends something else caused the death. And as trial counsel noted to the trial court, this does happen. The plaintiff goes to trial contending that a smoking-related disease causes the death, and a jury does come back from time to time and find it caused the disease, it didn't cause the death. So I understand, Your Honor's point about the phrasing in the complaint, but I would suggest that at the very least we should be allowed to go back and try on the survival claim. Finally, I said at the beginning of my argument that the trial court made 2 errors. I've only addressed 1. The alternative basis for the trial court denying the motion was that the plaintiff did not make a reasonable showing because she did not prove, or the estate did not prove class membership of the decedent. The precedents from this court, the state of Blakely and the state of Despain, called for the court to look only at the conduct element of punitive damages and not proof of the underlying claim. There's a whole separate procedure for testing the plaintiff's evidence for the underlying tort claim, and that is summary judgment. If the amendment is granted and R.J. Reynolds believes that there's insufficient evidence to prove class membership, it can certainly move for summary judgment, and that wipes out all damages, punitive and compensatory. So it was incorrect for the court to even consider that, but if it did, it was required to follow this court's instructions to accept all the contents of the proffer as true, to view them in light most favorable to the movement. The procedure does not call for countervailing evidence from the defense, and the court should not weigh evidence as between the plaintiff and defense. And the plaintiff did submit evidence of class membership. I note that there was some argument over whether the expert affidavit on manifestation was sufficient, but as trial counsel noted to the trial court, this is argued at the answer brief appendix 146 to 147. There is a medical record at appendix 1025 to 26 showing that the plaintiff's decedent was treated for chronic obstructive bronchitis, which is a subtype of COPD, back in 1994. So there was record evidence supporting the expert's opinion that there was manifestation in 1994. So even if the trial court was to consider class membership at this procedural stage, I don't think it was, but I think we satisfied it. With that, if there are no more questions, I will wait my rebuttal time.
Thank you.
May it please the court, Val Leffert for the appellee. Acting as gatekeeper as required under 768.72, subsection 1, the trial court properly rejected plaintiff's claim for punitive damages as futile. There can be no reasonable basis for recovery of punitive damages when the claim for punitive damages itself fails as a matter of law. My colleagues' arguments this morning run into the plain language of the 2 tort reform statutes that are at play here. And they would create conflict with the 3rd District's recent decision in Summers. And to address Judge Edwards' question, there was a compensatory award in a first trial in Summers. But then on remand, the trial judge granted summary judgment as a matter of law on punitive damages because any evidentiary hearing on the exception in 2B would be rendered futile because of the $198 million that Philip Morris USA had paid in prior cases. And the court said, and the 3rd District affirmed on the noble review, that there's no way that any plaintiff here could recover more than the 198, which means that the last clause of 2B would erase it. Any award below 198 would be offset by 2B, the last clause.
So in Summers, there was $1 million compensatory. So if you apply the subsection 72 ranges, you're either at 3 times or 4 times that as a yardstick, correct?
Correct.
So that kind of went into the reasoning of the trial court there and into the 3rd DCA's reasoning. We don't have that here. That was one thing that troubled me a little bit. And there was another case too where I think there had been a $500,000 award. Here we don't have the foundation. I mean, it would be hard to conceive that somebody could get a $200 million compensatory award. But until there's actually something there, how does the trial court go, it's impossible? Because that's basically what he said.
Sure, because the first tort reform statute requires to an assessment of, is this reasonable? Is the theory put forth, right, the first step of this court's decision in Varnador, is the theory that's set forth by the plaintiff, does that provide a reasonable basis for recovery? And then the second step is there an evidentiary proffer reviewed in the light of the plaintiff? Does it support that theory, right? And just on that first step, if the theory is we have a single plaintiff wrongful death case, right, brought by a 51-year-old son who lost his mother when he was 51, his mother was 81 years old. She was born in 1924. She lived to be 81 years old. He lost his mother when he was 51 years old. That's the only claim in this case. This is not a consolidated action. This is not 6 children, right, who lost their parent at the age of 4 years old. This is none of these things. And we know that if an award came in, a very high compensatory award, 0.74 will kick in. And 0.74 says, it is the legislature's determination that such damages award shall receive close scrutiny by the courts. And if anything that could serve as a reasonable basis to then get the punitive damages past 479, Philip Morris is at 198, we're at 479. Anything that would then allow essentially a punitive award over 479, just to have the required basis for that in the compensatory award, would require a compensatory award in the hundreds and hundreds of millions of dollars. And Odom, of course, says that this is not a one-size-fits-all solution as to what was awarded in this case, in that case, but there's nothing that even gets close. Townsend from the First District says 10.8 for a spousal award is the outer limit of reasonableness. We've got nothing in English Project case, and we have over 300 of them, where an adult child, let alone a 51-year-old, recovered a compensatory award anything near an amount that we could then use as a basis for a punitive damages award of $479 million. So what then kicks in, and Your Honor asked, well, there's really no order of how this works. Well, it's a trifecta of reasons, right? The Third District jumps straight to due process, okay? What I would read from the Supreme Court's analysis in codes is that, why do we need to go there, right? We can just go with 0.74. That's the first check, right? Then we can go with 0.73, subsection 1. And when we look at subsection 1, and Your Honor asked, well, is there really an order to it? Well, 1 comes before 2, and 1, the plain text of 1, says an award may not exceed. An award of punitive damages may not exceed. So that tells me that in determining whether an individual award is excessive, as a trial court, I have to look at 0.73, subsection 1. Because that's the section in the statute that deals with excessiveness, when the award is excessive. An award may not exceed. And then when we go on in, we continue reading in 0.731, it tells us a fact finder may award, if a fact finder finds conduct solely motivated, right, by financial gain, it may award. It specifically says what a fact finder may do. Now, my colleague is, of course, right that a jury, right, is not told about this background information, and they could go into this jury room right there, and they could write down $570 million. They could write that down, and it's happened in tobacco cases. It has happened. But the first part, the first tort reform statute, talks about recovery of punitive damages. And there has to be a reasonable basis for that, not what a wildly excessive award, what an impassioned jury could do. And in fact, you could have an award the jury was not impassioned, but still it is excessive as a matter of law. And there you have a trifecta of judicial checks. 0.74, 0.73 subsection 1, which becomes before 2, and it addresses the question of individual excessiveness, whether the award is excessive. 0.2 that talks about award, the same language, right, and applies to that award, the award that is the product of the review that already happens of subsection 1. So I think there is an order to it. And then, if as a safe fail, if you will, as a backup, there's a due process review. Because you couldn't imagine a scenario where, let's say, we have a wildly high compensatory award, and the trial court says, I'm going to let that stand, okay, under my .74 review. But to then say, the compensatory award is already $100 million, right, and somehow that survives .74, due process would kick in and would not allow a ratio of 4 to 1 or 5 to 1 on top of $100 million. Townsend says 4 to 1 is constitutionally excessive if the compensatory award in a wrongful death case is 10.8. They call that the outer limit of reasonableness and say constitutionally it can't be elevated to a 4 to 1 ratio at that point. In other words, just on the first step of the Varner-Moore analysis, is this even a reasonable theory, right? We don't even need to dive into the evidence. I think we have to set ourselves, is this even possible that there is a reasonable basis for recovery of it, and the trial court correctly concluded there was not. Procedurally, there's not. When I read this court's case law in Varner-Moore, Dean, Crump, it's not that different than summary judgment, right? Where you do the first step, what is the theory? That's a lot like a motion to dismiss. And then the second step is, what is the evidence in the record or proffered by the claimant? That's two components, right? It's evidence in the record regardless of who puts it in, or proffered by the claimant, right? View that in the light most favorable to the plaintiff. And I think that's the exact same analysis that the 3rd District affirmed, albeit at summary judgment, in the Summers case.
Counsel, I'd like to ask a quick question looking at the statute, looking at 2A, 768% versus 2A, and it talks about how punitive damages do not be awarded, so on and so forth. And it basically, what the legislature has said here is punitive damages may not be awarded, period, if they've been awarded previously, right?
Yes.
So, as I read the statute under 2A, it just takes punitive damages off the table entirely. If, quote, before trial, there's this determination of punitive damages that have been previously awarded with the same course of conduct and so forth. That applies in this case, right?
Correct.
So,
We all agree this.
right, but there's already been punitive damages for the same conduct, right? So that, as I read that, it's off the table. And it's a determination that's been made before trial that we've had punitive damages before awarded for the same behavior. We're not signing an issue in this case. Is that how you read it?
That's how we
Okay. So the way a plaintiff would only be able to bring a claim for punitive damages would be to meet the exceptional bid.
That's right.
Okay, so you have to clear convincing evidence that what has been awarded today has not been enough. The struggle I have a bit is 2A talks about before trial, 2B does not talk about before trial. And that's where Chief Judge Edwards is out looking at some of these issues. And that's why I'm struggling a bit is how procedurally the timing of these things should occur. If I'm a plaintiff, what do I have to do? Because I mean, it is plausible. I mean, if you had inflation in healthcare costs, and high awards could become very high in the future, so that $450 million today may not be $450 million 10 years from now. But help me on the timing, how would the exception would work, where it doesn't say before trial?
Well, Your Honor is correct. We have an obligation to invoke it before trial, right? And the first time we ever invoked this statute in the state of Florida, the plaintiff actually said we waived it because we didn't raise it in opposition to the motion to amend, right? The .72 subsection 1 argument, saying this is a legal bar, you should have raised it immediately the moment you were faced with this claim, which is what we did. The first time we were faced with the claim, we invoked it, and the 2A analysis happens, right? Now, I would grant Your Honor, from a timing standpoint, that a plaintiff could say, right, but I can meet the exception in 2B, and that requires an evidentiary hearing. I'm ready to do it, Judge. I'm ready to provide you with clear and convincing evidence, right? I don't think the plaintiff actually did that here, but even assume for a moment that they did that here, right? That's where the futility analysis comes in, right? And that's where the last clause renders the first part of 2B futile in our situation. In many situations, just make I think your question would be answered differently. It would be answered that, yep, we've invoked 2A. The plaintiff wants to meet the exception 2B. We need to schedule an evidentiary hearing. right? And then it would, I think, I would probably merge with summary judgment or something like that, right? I mean, in a lot of these cases, there's not that big of a discovery period anymore, but it's going to happen, it would happen somewhere in between there. At the latest, it would happen in summary judgment.
But what about their claim that, hey, we need discovery, we need financial discovery, so forth?
Twofold. Legally and practically, that's not a good argument. Here's legally. Legally, there's no way that anything about our finances would change the trifecta of reasons that I've just outlined. We could be the richest company in the world. We could be Amazon. And still, 0.74, 0.73 subsection 1, and federal due process would kick in. The same analysis about it's unreasonable to award them $150 million in compensatory damages, and it would be unconstitutional, even though we're the richest company in the world, to then award $479 million of punitive damages. So the finances, right, even the finances don't change the analysis. That's the legal answer to it, right? Even though you're rich, you don't lose the due process right, you don't lose the application of 0.74, you don't lose the application of 0.73 subsection 1. Practically and factually here, it's a non-starter in tobacco cases because we have provided that discovery again and again and again. They have an economist, the plaintiffs, right, whose entire work is to study the finances of the tobacco companies, go through the 10K, which are publicly available, right? This information is publicly available, and to deduce from that, how much money do they make a day? How much money do they, what are the profits? What are pure profits? What's being paid out as dividends? How much is sent to the parent company? I mean, they have that down to a T. And on top of that, and I know this court issued the opinion in Coates, going through these issues in detail and citing all the cases that have come out of this. There is extensive case law assessing that framework of punitive damages, including the impact of finances, if at all. And no one disputes that the companies have a lot of money. So when you look at the reprehensibility analysis, balance against the ratio analysis, all of these things that have already been done, I don't know, 10, 15 times in tobacco cases. Even assuming that we're Amazon, it wouldn't change that the award would be excessive under 0.74, 0.73.
The last sentence of 2B seems to be moving almost everything else, perhaps. What's it in such punitive damage or otherwise reduced by the amount of earlier punitive damage or the state before.
That's it.
If that is taken as plain meaning, if you were, how much for it?
479, and it's actually higher. I mean, this is what it was at the time that we moved.
Yeah, it seems to me that in any case where they're seeking to add plain punitive damages, and it's already 479 million, they have an uphill road because, as we discussed earlier, under what set of circumstances could they ever get an award
Right.
that would not be reduced?
That's really it, because the first statute requires a reasonable basis for the recovery, not just a reasonable basis for the notion that a jury could get really mad and award a lot of money or write it down on a piece of paper. It's a reasonable basis for recovery.
Do you see recovery as meaning entitlement to a judgment?
No, actually collecting.
Like,
Yeah, recovery. I mean, recovery means recovery. Right? That's how I read it. But
it's even more difficult than a judgment.
okay, I'll settle on judgment.
It's more than just the jury's reward,
It's-
more than the verdict.
More than what they could write down in that room over there. Yes, I think that's right. I mean, it has to be that, right? And reasonable basis in general, I don't think we can take out of the calculus 0.74, which says close scrutiny, right? And the legislature said close scrutiny. 0.73 subsection 1, which sets forth a framework about what may be awarded, and using that same language that's then used in the very last clause of 2B, right? 2B, the last clause talks about an award. Well, before you deal with what an individual award may be, you have to go through 0.73 subsection 1, which we know from Coates does not foreclose also the consideration of 0.71, and then I believe due process comes in sort of as the last safeguard there.
At what point did enable plaintiff cases Yeah, mortality table, I think, together, so.
We're down to maybe, I think we're down to less than 100, I'm told. So it's very few. You know, the federal cases all resolved as a package after a few bellwether trials. And now in the state court trials, I think we've done over 300 something, 300 that were actually tried, to 350 maybe in that number. And I think we're down to 100 or less, or in that neighborhood. Yeah. Seeing no further questions.
Thank you.
Thank you.
All right, thank you, Your Honors. I'll see what I can get through in 4 minutes. The word recovery in the statute, we're looking at the sufficiency of the plaintiff's proffer. So recovery should mean, does the evidence support a jury's conclusion, or would it support a jury's conclusion that this plaintiff would recover punitive damages? And the reason I don't think it means final judgment is because there are any number of ways that a final judgment can take away punitive damages from a jury. As opposing counsel pointed out, the text of 768-72 has never been read to include those post-trial or post-evidentiary submission reductions in punitive damages, either through the due process clause or through other Florida statutes.
What verdict would you have to get in order to be able to keep punitive damages in a case like this?
Well, it would have to be
What do you have to
pretty
get
big,
in
Your
terms
Honor.
of compensatory?
Well, okay. I think we're starting at a different spot from each other, Your Honor, because, of course, the jury's award of punitive damages would have to be way out of proportion to the compensatory damage award. But the statute already presupposes that's going to happen, right? I mean, every statute dealing with remitted or damages presupposes that the jury is going to award something way out of proportion to the compensatory damages. That's why subsection 1 of 768-73 exists. That's why the due process analysis in State Farm versus Campbell exists, because we know juries are going to do that. I will point out that in a lot of trials, plaintiffs have been prevented from putting on all the evidence of how unreformed R.J. Reynolds is, or how unreformed Philip Morris is. What this new statute, new in the Anglo world anyway, puts in place is consideration of just how unreformed these companies are. That's part of what the plaintiff has to prove now. So, yes, we have to ask the jury, or we have to hope that the jury comes up with a number that's way out of proportion to the compensatory damages, but since that's what the statute contemplates in the first place, we should be allowed to do that. And, you know, the Anglo jury found that the punitive damages would be something like $150 billion. Obviously, the Supreme Court took that away, but the point is that a jury who hears all the evidence of how bad these cigarette companies were can come to a number like that. And there are, nobody's disputing that there are procedural safeguards before that gets put in a final judgment, but that's what we're here to do, to set the stage for all those procedural safeguards to be invoked. The order in which you do these things has never been explicitly determined. And I would suggest that this court should not issue an advisory opinion before a jury has ever even delivered an award, saying the trial court should do this first and this second and this third. I would suggest that the setup for prior awards is probably the first and easiest thing to do, because the trial court has already made all the findings, already made the finding that they've been punished before, already made the finding that the punishment hasn't been enough, and whatever else subparagraph 2B calls for. And then after that, it's just a matter of math work, looking at the jury award and subtracting a number from it. Subsection 1 of the statute really duplicates the due process analysis, and also includes a provision where there's no cap at all. So the order in which you do those things should be left to the trial courts to work out first. There will be conflict, of course, if this court reverses. We welcome that. We welcome the court to certify conflict with Summers, and this would be an opportunity for the Supreme Court to tell us what these things mean. There is already conflict between this court and the 4th District on how the court views the proffer. In the Perlmutter case, the 4th District certified conflict with this court's decision in the state of Spain. These issues are going to the Supreme Court anyway. We might as well pile them up, I suppose. With that, my red light is going off. I'll answer any questions, but I thank you all for your attention, Your Honors.
Seeing none, thank you both. Very well briefed, very well argued.